Hello, magandang hapon. At ngayon po ay alas 6 na ng gabi. Ang ating pag-usapan po sa ngayon ay yung pagbebenta nila ni Luistro, ni Delima, at saka ni Ridon. Sa pangunguna nila, ang Pilipinas ay binenta nila sa Kabatan, kay BBM. So, saan ba yan, ano? Yan lang. So, ito na, ano? So, ito. Ipagbenta nila kay ang Pilipinas, binenta ng mga tarantada. Nasaan na ba tayo? Ito. Paano nila binenta? Binenta po nila sa pamamagitan ng pag-dismiss ng kasong impeachment laban kay BBM. Na dapat sana ay hindi nila dinismiss kasi obligado sila na ipatuloy ang pagkaso. Ang kaso na sinampa kay BBM, ladies and gentlemen, ay sapat ang pagkabanggit ng detalye. Nakasaad sa batas nila na kapag sapat ang pagbanggit sa detalye, ay patuloy. Pero ang ginawa nila dito, binasura nila. Okay? So, itong si Gary Bacares, pang ano ka lang, pang kwento ka na binenta ko, paano ko ibebenta sa Duterte? Wala namang pera binigay yan. At saka kung mag-imbento ka niyan, asan ang ebidensya mo kung hindi kakasuhan kita ng libel? Pakita mo ebidensya mo. Pagbibigyan pa kita. Maya pabengi sa Galaxy. Ito po ang pagbenta nila. Una, ipakita ko muna yung speech ni Jinky Luistro. Ito.
Luistro, Chairperson of the Committee on Justice, is hereby recognized.
Ayun ang idol mo, Gary Bacares.
Madam Speaker, distinguished colleagues, ladies and gentlemen, I rise today to sponsor the committee report and the accompanying resolution.
Sponsoran mo committee report na pagbebenta na dapat kinasuhan si BBM tapos hindi nyo kinasuhan. Ipakinggan natin.
From the Committee on Justice, formally recommending the dismissal of the 2 impeachment complaints filed against President Ferdinand R. Marcos Jr. The first complaint, the De Jesus complaint, was filed by Attorney Andre R. De Jesus and endorsed by the Honorable Representative Journey Jet V. Nisay of the Pusong Pinoy Party List. The second, the Masa et al. Impeachment complaint, was filed by Liza Largoza Maza, Teodoro A. Casino, Renato Reyes Jr., Attorney Nery Colmenares, and 32 other complainants endorsed by the Honorable Representative Antonio Tino of the ACT Teachers Party List, Honorable Representative Sara Ilago of the Gabriela Women's Party List, and Honorable Representative Rene Luis Co of the Kabataan Party List. The Supreme Court, through its latest resolution,
para hindi na mahaba kasi mapapilit lang kayo mahaba ang pag-deliver. Ipakita ko na lang yung tinatawag na resolution ng committee report. Ito pa yung committee report. Ipakita ko na lang. Ito sa committee report, yan din ang binabanggit niya dyan. Ito po ang committee report. Committee report number 111. Binigay doon ng February 9, 2026. A resolution dismissing the complaints for impeachment filed by Attorney Andre R. De Jesus and by Lisa Larguza Masa, Eudoro E. Casino, Renato Reyes Jr., Attorney Nery Colmenares et al. Against President Ferdinand Bongbong R. Marcos Jr. Recommending the adoption of the findings, conclusions, and recommendations of the committee in the matter of the impeachment proceedings against President Ferdinand Bongbong R. Marcos. Sponsors, Representatives Attorney Jervil Jinky Lucaric Beatrix R. Luistro, Mauricio Dumugan, Jennifer Lagbas, Alfredo Garbin Jr., Brian Poe, Jose C. Alvarez, Jonathan Kate Flores, and Isabel Maria J. Zamora. So, itong sinabi niya. Resolution dismissing the complaints for impeachment filed by attorney. Okay, ito na. On January 19, Attorney Andre De Jesus, a private citizen, filed with the Office of the Secretary General an impeachment complaint. And attached to this report as Annex A, together with its annexes, against President Marcos Jr. The complaint was subscribed and sworn to by Attorney De Jesus before a notary public on January 19 and was accompanied by a resolution of endorsement subscribed and sworn to by Representative Jerny Jet V. Nisay of the Pusong Pinoy Party List before the Secretary General of an event date. Tapos on January 26, Lisa Larguza Masa, Teodoro Casino, Renato Reyes Jr., Atty. Nery Colmenares, and 32 other complainants filed their impeachment. Okay? Diretso na tayo dito. Grounds for impeachment as alleged. The De Jesus impeachment complaint alleged 5 grounds for impeachment against respondent President Marcos. Namely, number 1, respondent ordered and enabled the kidnapping of former President Rodrigo Roa Duterte. Respondent is a drug addict whose condition impairs his judgment and leadership. Respondent failed to veto unprogrammed appropriations and other unconstitutional provisions in the General Appropriations Bill for 2023, 2024, 2025, and 2026. Respondent benefited from kickbacks arising from budget insertions and ghost flood control projects. And number 5, respondent created the ICI to shield corrupt allies. Ang detalye po nito pagkabanggit ay kompleto sa reklamo nila. Tapos, ground for impeachment as alleged in the Masa et al. Impeachment complaint. The Masa et al. Impeachment complaint alleged 1 ground for impeachment, betrayal of public trust, consisting of 3 distinct but interrelated related acts, namely, institutionalizing systemic corruption through baseline balanced managed BBM parametric formula of allocables, abuse of discretionary power over unprogrammed appropriations, and direct personal involvement in budgetary insertions and kickback schemes. So, yan preparatory statement. This is the first impeachment. Okay, proceed tayo sa rules of procedure in an impeachment proceedings. Accordingly, the rules of procedure impeachment proceedings in the 19th Congress was adopted for the 20th Congress on July 28, 2025 and was published on July 29, 2025 in the Philippine Star and the Manila Standard. Determination of sufficiency in form. The Committee on Justice held a meeting on February 2, 2026 to determine the sufficiency in form. So, sufficient ang form. Paano ba sufficient ang form? Filing and referral of verified complaints. A verified complaint for impeachment by a member of the House or by any citizen upon a resolution of endorsement by any member thereof shall be filed with the Speaker, Office of the Secretary General, and immediately referred to the Speaker. An impeachment complaint is verified by an affidavit and that the complainant has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic records. An impeachment complaint required to be verified which contains a verifications based on information and belief or upon knowledge information o huwag nyo na palabain ito. Ang ibig na sabihin, kapag may nakakabit sa reklamo ng impeachment na tinatawag na affidavit o sinumpang salaysay na tinatawag na verification at may nakakabit na endorso, pag-endorso ng congressman ay sapat na siya. So magiging sufficient informed na siya. Ito nakalagay dyan, so determination of sufficiency informed. Upon due referral, the Committee on Justice shall determine whether the complaint is sufficient informed. If the committee finds that the complaint is sufficient informed, it shall return the same to the Secretary General within 3 session days with a written explanation of the insufficiency. The Secretary General shall return the same to the complainant together with the committee's written explanation within 3 session days from receipt of the committee resolution finding the complaint insufficient informed. So, endorsement of the DESOS and Masa et al. Complainants. So, sa pagtingin nila, parehong nakapasa ang reklamo na sinampa ni Atty. Andre De Jesus at saka yung reklamong sinampa ng mga Liza Masa et al. So, ibig sabihin, tama ang kanilang pagkalagay ng kanilang tinatawag na verification. At saka mayroong pag-endorso ng congressman. Okay? So dito na tayo nagkalintik-lintik determination of the sufficiency and form of the Masa et al. Impeachment complaint. Unahin natin sa Masa et al. After the determination of sufficiency and form of the De Jesus complaint, the Committee on Justice proceeded to determine the sufficiency and form of the Masa. O na-aprobahan din siya. So ngayon, next is determination of sufficiency and substance. So having determined that the De Jesus impeachment complaint and the Masa et al. Impeachment complaint are both sufficient and form, the Committee on Justice proceeded to determine the sufficiency and substance of the said complaints in its meeting held on February 3, 2025. At the start of the discussion on the sufficient substance of the impeachment complaints, a query was raised on whether the authenticity of the annexes to the impeachment complaint should be excluded in the determination of sufficiency and substance. The argument raised in favor of the exclusion of the authenticity of the annexes to the complaint is that at this stage of the impeachment proceedings, the only determination that should be done is whether the complaint contains a recital of facts constituting the offense charged and determinative of the jurisdiction of the committees. So the determination of the authenticity of the annexes to the impeachment complaint can come during the hearing. On the other hand, the argument raised against the exclusion of the authenticity of the annexes to the complaint is that it is the responsibility of the committee not to simply accept the recital of an impeachment complaint. Rather, the committee should determine such recitals with diligence. The determination of sufficiency in substance should at least be supported by facts that will help determine whether there is probable cause that will be further heard during the hearing by the committee. Thereafter, a motion was raised to exclude, in the determination of the sufficiency in substance, the consideration of the authenticity of the annexes to the impeachment complaints. The chair put the matter to a vote. So may motion na sinampa, si Delima po nagsampa ng motion na to. Na sabi na pagbutubutuhan na ang sufficiency in substance ay dapat hindi na isama ang titingnan kung ang mga annex ay authentic o hindi. Yun lang pinagbubutuhan. Alam mo, wrongful mistake. Mistake na wrongful na. Wrong dito si Delima. Bakit wrong si Delima? Kasi po, mismo yung rules of impeachment nag-uutos na nagsasabi na sapat na ang pagbanggit ng tinatawag na mga detalye, basta sapat ang detalye na maka-impeach ay sapat na yun. Hindi na hahanapan ng ebidensya na nakakabit. Yun lamang. So para maniwala kayo sa akin, ilagay ko muna rito yung Rules of Impeachment. Section 5, basahin natin. Ito yun, Section 5. Determination of sufficiency in substance. Should the committee find the complaint sufficient in form, it shall then determine the sufficiency in substance. Tapos the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. Alamin lamang po kung ang mga detalye na kailanganin para ma-impeach ay nakasulat. Kung nakasulat, diretso na sila. Hindi sila allowed na titingin sa mga dokumento. Ang ginawa nila, itong luko-luko, kakampi nila si Delima, nagkunwari siya na hindi siya maabot ang diskarte niya. Ang ginawa niya, nag-motion siya sa committee na dapat hindi na, bito mo, ang ganda na pagka-frame ng question, ng motion na, dapat hindi na hanapan ng dokumento ang mga detalye. Si Luistro naman, dito na nagkamali si Luistro. Bakit isinumiti niya sa members ng committee pabuto-butuhan? Kung dapat ba hindi titignan ang mga dokumento na nakakabit? Akalain mo. Utos na ito, batas na ito ha. Batas na ito ng tawag nito. Asa na ba yan? Batas na ito ng House of Representatives. Kabuuan ng House of Representatives tapos babaguhin lamang ng committee. Yan o. Walang kapangyarihan ang committee magbago ng procedure. Kasi ang procedure na ito ay ginawa ng pinaka-boss ninyo. Lahat ng congressmen ang gumawa niya. No? Rules of Procedure in Impeachment Proceedings. Yan. Ang inyong kabuuan, lahat ng member ng House of Representatives. So dahil doon, sa kunwari petition o motion ni Laila Delima, ay ang nangyari, nagbuto-butuhan. Ito na. Pagbuto-buto, natalo pa ang motion ni Delima. Kunwari lang yung motion ni Delima. Nakuwitin Delima ko talaga. You have given our country this big dilemma sa ginawa mong yan. O yan ang nakaan. Thereafter, a motion was raised to exclude in the determination of the sufficiency and substance the consideration of the authenticity of the annexes to the impeachment complaints. So, tinanong niya ang mga membro, payag ba kayo? Natanggalin na lang ang huwag na tayo tumingin sa ebidensya sa mga dokumento. Tapos tingnan na natin ang mga nakabanggit. Kung sapat na, okay na yon. Sapat na para ang mga elemento ay nabanggit, ay tuloy-tuloy na tayo sa impeachment na grounds. Impeachment na probable cause determination. Akalain mo pabuto-boto, kaya ang bumoto, 21. Siyempre, ang 21 na bumoto, ito ay paborito dahil iyan naman ang batas. Tapos 24, mas marami bumoto sa kontra. Kaya ang nangyari, diniklara ng chair ni Luistro na susundin nila, titignan nila kung may authentic na may sufficient. Para maging sufficient in substance, ay titignan nila ang dokumento. Ganun po nangyari. Una best po, hindi dapat lumabag si Luistro pati members ng committee na binago nila ang rules of the game. Ang proseso binago nila. Hindi dapat sinumiti sa motion yun. Kasi only Congress as a whole, kabuuan ng House of Representatives, yun lang po ang pwede magbago niyan. Bikalain mo, lahat ng congressmen nag-approve naman, tapos binago lang ng mga 24 tsaka 21, 45 na congressmen. Kalukuhan. So, ibig sabihin, dapat ang trabaho ni Jerbil Beatrix Lucarit Luistro doon ay dapat hindi niya pinabuto-buto. Sasabihan niya, i-remind niya ang lahat ng mga congressmen, "Hoy, ang gumawa ng batas na ito, ng proseso, ay yung kabuuan na membership ng House of Representatives. Kaya tayo na mga member ng committee lamang na maliit na particle lamang ng House, buong House, ay wala tayong karapatan at kapangyarihan na baguhin natin ang proseso na ginawa ng House of Representatives. Besides, pinapublish pa yan sa dyaryo. Ngayon, ang inyong pagbago ng rules sa procedure, hindi naman lang na-publish sa dyaryo yun. So, doon nagkaroon kayo ng grave abuse of discretion. Because of that, binenta nyo kay Marcos ang Pilipinas. So, natural, ang nangyari, resulta, hinanapan nga nila ang lahat ng reklamo laban kay Marcos ng ebidensya ko nakakabit. So, tanong nila, may ebidensya ba yan? May ebidensya ba yan? Ang batas po ay nag-uutos na huwag niyong hanapan ng ebidensya. Kasi ang paghahanap ng ebidensya, sa sunod pa na proseso sa kasunod na hakbang. Ngayon, dahil hinanapan nila, napilitan ngayon magbanggit si Tinio, si Congressman Tinio, na sa kaso nila sa pagdakaw sa flood control, meron silang ebidensya na isang sinumpaang salaysay ni Undersecretary Adrian Bersamin na kung saan nagsasabi ay inutusan siya ni BBM na kukunin ng 8 billion. At doon dinala, kinuha niya doon sa ilalim na sa basement parking ng Diamond Hotel sa Malate, Manila. Tapos, binanggit ni Adrian Bersamin doon sa kanyang sinumpang salaysay ang screenshot ng palitan ng text ni BBM at saka ni Adrian Bersamin. Isa sa mga palitan doon, binanggit doon ay sinabi ni Adrian Bersamin, "Boss, sir, andito na pong 8 billion. Sabi, sagot ni Marcos, "Be good, very good." Ang laki-laki ng ebidensya. Tapos tinapon nyo. So, ibig sabihin, ladies and gentlemen, para lang po itong basketball na sabihin niya ay bawal maglaro ang hindi Pilipino. Tapos, pag umpisa ng game, natatalo na yung kabilang team, nagpapasok ng ng Amerikano. Tapos, binago nila sa gitna ng laro, binago nila, pwede ng Amerikano. Hindi po pwedeng gano'n. Ganon din po ang impeachment, hindi mo rin pwede baguhin ang proseso, ang batas ng proseso. Dito binago nila. Kaya nagkahindot-hetot, hindi daw ebidensya, hindi raw sapat na ebidensya para patunayan mong adik si BBM, hindi raw sapat na ebidensya si Amy Marcos na nagsalita, nag-speech. Hindi rin daw sapat na patunayan na yung pagtanggi ni BBM na magpa-hair follicle test ay hindi raw sapat na dahil nawala pa doon sapat na ebidensya para nasabihin natin na bangag si Bongbong Marcos. Kaya nagbuto-buto sila na hanapan ng ebidensya kasi alam nila doon sila lulusot. Sa mga pagnanakaw na akusasyon, mali-malit ang pera, sinight nila na ebidensya yung pagsalita ni pagsalita ni Saldico at saka ni Gutesa. Lately, kung nahabol lang sana yung 18 Marines, hindi lang nahabol eh. So, yan po ang larawan ng ng akusasyon laban kay BBM. Pero, nagbuto-buto sila at hindi tinanggap. Yan po ang nangyari. So, sinabi ito, the chair put the matter to a vote with 21 votes in favor, 24 votes against and 0 abstentions. The chair, si Luistro, declared that the authenticity of the attachments or documents to the impeachment complaints shall be considered. So ano nangyari? Sa Jesus complaint, basahin natin kung ano nangyari. The proceeding to the determination of the sufficiency and substance of the Jesus impeachment complaint, some members of the committee emphasized that under Section 5 the rules, a verified impeachment complaint is sufficient in substance if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. So Section 5, determination of sufficiency in substance. Should the committee find the complaint sufficient in form, it shall then determine if the complaint is sufficient in substance. The requirement of the substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. If the committee finds that the complaint is not sufficient in substance, it shall dismiss the complaint and submit its report as provided thereunder. So kaya ngayon nangyari, a discussion ensued whereby members of the committee proffered that the Jesus impeachment complaint was insufficient in substance for the following reasons. Number one, the arrest of the former president is pursuant to the Philippines' commitment and membership in the International Criminal Police Organization or the Interpol. In addition, the arrest was an implementation of a warrant issued by the ICC and sent to the Interpol for execution, and the assistance of the law enforcement agencies of the Philippines was enlisted in the implementation of said warrant. The arrest was by virtue of a warrant of arrest issued by the International Criminal Court for an offense which has allegedly been committed when the Philippines was still a member of the ICC. Number two, there is no overt act attributable to the president with respect to the arrest and alleged kidnapping of the former president. There is likewise no factual allegation with respect to the allegation that the president surrendered the former president to a foreign tribunal and disregarded domestic legal processes. Number three, there have been cases instituted before the Supreme Court, primarily a petition for writ of habeas corpus of Rodrigo Roa Duterte, among others, which precisely seek to question the arrest and alleged kidnapping of the former president. Hence, to attribute the illegality of the arrest and the alleged kidnapping to the president is premature and baseless. Number four, the allegation of drug addiction fails to allege the ultimate facts of when the alleged use of illegal drugs occurred, how it was committed, and how it affected any official function. Number five, the allegation of drug addiction based on the alleged statements of the sister of the President, Senator Amy Marcos, and accompanied by an affidavit, authentication, or corroboration is mere hearsay. Hindi nga dapat tingnan kung may hearsay eh. Kasi bawal tumingin dapat eh sa mga dokumento eh. Just mere statements lang eh. So mere hearsay daw and lacks probative value in impeachment proceedings. The allegation lacks independent corroboration. The allegation remains purely speculative. There are no sworn statements, medical findings, drug test results, official investigation on record presented to support this allegation. Number six, the power of the president to veto a specific item or items in an appropriations bill is purely discretionary. No, hindi discretionary yan. Mandatory po yan. Standing alone, failing or refusing to exercise line item veto of the budget bill does not amount to an impeachable offense. Kabaliktaran mga binabanggit nila. As enrolled bills submitted for the signature of the president carry a presumption of constitutionality upon passage of both houses of Congress. Moreover, even if such line items are declared unconstitutional, it does not retroactively convert the president's non-exercise of a discretionary power into an impeachable offense. Number seven, the decision in Pimentel versus House of Representatives, December 5, 2025, merely struck down as unconstitutional a certain special provision in the 2024 General Appropriations Act. The said decision was promulgated on December 5, 2025, after the enactment of the 2023, 2024, and 2025 General Appropriations Act. and after the deliberations for the 2026 GAA. The inclusion of unprogrammed appropriations has been practiced since 1989 up to the present, once included and approved in the national budget. Unprogrammed appropriations are implemented by the agencies concerned and not by the President. This allegation, the allegation that the President benefited from kickbacks fails to identify any specific line item, project, program, or special provision in the GAA that was supposedly inserted at the President's directive, does not state the exact amount allegedly inserted, and does not plead any overt act, any act personally performed by the President to effect the alleged insertion. There is no recital of fact that will constitute a violation of Republic Act 3019, otherwise known as the Anti-Graft and Corrupt Practices Act. Ang daming binanggit. Tapos sabihin nyo wala. So the statements of former Representative Elizalde Escu on his video confessions regarding the funds from flood control projects being delivered to the President's allies are mere hearsay. Hindi nga dapat tingnan kung hearsay o hindi kasi hindi kayo allowed tumingin sa dokumento as they were not made under oath. The complaint likewise does not contain any sworn affidavits or authentication, nor does it meaningfully address the possibility that the statements are self-serving or politically motivated. The creation of an independent body like the Independent Commission for Infrastructure is an exercise of executive policy. Moreover, the integrity and competence of the members of the ICI belie the allegation that the ICI was created to shield the corrupt allies of the President. The investigations conducted by the ICI involve both allies and non-allies of the President. The complaint fails to allege ultimate facts showing abuse, unlawful purpose, or concrete acts of favoritism attributable to the President. Policy failure or perceived ineffectiveness of an office is not impeachable offense. Allegations of selective enforcement of the laws require proof of intent, which complainant failed to demonstrate. Number 12, the complaint failed to allege in his complaint that the President acted in bad faith with clear intent to violate the Constitution in creating the ICI. The Committee on Justice exhaustively debated on the sufficiency in substance of the DHS's impeachment complaint. Thereafter, a motion was raised to declare the said complaint insufficient in substance. There being an objection, the chair put the matter to a vote with 42 votes in favor and 1 against and 3 abstentions. The chair declared the DHS's impeachment complaint insufficient in substance. Tangina. Kita nyo na, kahit na sapat ang pagbanggit, tama yung mga detalye, binasura nila. Dapat hindi kayo nagbuto-buto. Kasi a matter of fact lang yun eh. A matter of factly na ang nature ng inquiry ay hindi siya titingin sa napakalalim. Titingin ka lang sa mukha pa lamang ng dokumento, alam mo na kung nasunod ang lahat ng pagkabanggit ng mga detalye na kung totoo ang detalye ay pwede na ito magiging dahilan para i-impeach si BBM. Pero bagkos ang ginawa nyo, binago nyo ang rules. Ginawa nyo, hinanapan nyo ng ebidensya. Dapat hindi nga dapat hanapan. So next, determination of the sufficiency of substance of the Masa et al. Impeachment complaint. Ito naman. Having established that the DHS's impeachment complaint was insufficient in substance, the members of the Committee on Justice proceeded to the determination of sufficiency in substance of the Masa et al. Impeachment complaint and presented arguments for and against the sufficiency in substance of the said complaint. The arguments in support of the sufficiency in substance are as follows. Number 1, the high-level budget allocation formula, an official document of the DPWH, contains the baseline balanced managed parametric formula, which is adopted in the National Expenditure Program preparation. This is the budget signed by the President and submitted to the Congress, which becomes the basis of the General Appropriations Bill. Number 2, while there are conclusive allegations in the complaint, there are factual allegations as well, which when hypothetically admitted, can establish nexus to the alleged ground of betrayal of public trust. A liberal treatment of the ground of betrayal of public trust would favor a finding of sufficiency in substance despite the presence of the conclusive allegations as opposed to the factual allegations. So inamin pala nila yung reklamo na sinampa nila ni Lisa Masa ay sufficient in substance. Oh. The recital of facts considering the offense charge and determinative of the jurisdiction of the committee is supported not only by the statement made by Representative Co, but is likewise supported by the sworn testimony of Undersecretary Roberto R. Bernardo, who can be summoned and can perform his statement and corroborate the statement of former Representative Co. Segundo to si Elisaldico. Si Saldico. On the other hand, the arguments in support of its sufficiency in substance are as follows. The BBM parametric formula appears in the WWH policy issuance or policy document, not in the presidential issuance of act or act personally attributable to the president. There is no evidence or official record showing that the president issued, approved, and or directly implemented the formula. Number two, there is no recital of fact that shows that the president authored, ordered, or used the BBM parametric formula or allocables to commit a corrupt act. The complaint merely infers culpability on the part of the president from the branding and from the managed stage of the policy, which contains the phrase priorities of leaders. Number three, with reference to the managed stage of the BBM parametric formula, which overrides technical criteria based on the priorities of leaders of the national government and legislature, policy coordination is not by itself an impeachable offense. Allowing coordination with leaders for large-scale infrastructure does not automatically constitute corruption or patronage. Number four, even if cabinet secretaries are considered as alter egos of the president for purposes of executive control, the doctrine of qualified political agency does not automatically convert every potentially culpable administrative issuance into a personally attributable and culpable act of the president. The complaint does not allege that the president directed, approved, ratified, or even knew of the parametric formula. Number five, during the State of the Nation address of the president on July 28, 2025, the president himself ordered an investigation into possible corruption in flood control projects. This demonstrates good faith on the part of the president in scrutinizing irregularities in the said projects rather than tolerating or willfully ignoring corrupt acts. Number six, unprogrammed appropriations are not prohibited by law and are in fact referenced under Section 35, Book 6 of the Revised Administrative Code of 1987. As stated in the GAA, unprogrammed appropriations are expressly authorized by Congress and may be availed of only upon the occurrence of statutory conditions and the required certification of availability of funds, and is therefore limited by the purposes expressly approved by Congress under the unprogrammed appropriations of the GAA. This underscores that the use of unprogrammed appropriations is predicated on non-compliance with statutory conditions and certification requirements and cannot be automatically equated with arbitrariness, illegality, or impeachable conduct. Number seven, certifying as urgent a bill such as the 2024 GAB and authorizing the release of funds are acts consistent with the normal course of duties of the President. Any unlawful use of disbursement of funds cannot be directly attributed to an act of President, certifying a bill as urgent. Even if the Supreme Court found special provisions of the 2024 GAA authorizing the transfer of excess or fund balances of government-owned or controlled corporations of unprogrammed appropriations, in the case of Pimentel versus Office ito yung PhilHealth Panda, this ruling does not establish an impeachable offense on the part of the President. Di ba ni-roll ng Supreme Court na null and void? So dapat may papel si, mananagot si BBM dito kasi siya nag-approve nun. Number 9, expenses for lump sum appropriations is not the President's sole prerogative. It is first prepared by a government agency, submitted to the Department of Budget and Management, which studies it and recommend the same to the President for approval. The doctrine of operative fact recognizes that a law or executive act is presumed valid and constitutional while in force, and even if later declared unconstitutional, may still produce valid and legal effects, especially if people relied on it on good faith. Hence, the provision in the 2024 GAA authorizing the transfer of excess funds of all government-owned or controlled corporations to the national government is presumed valid when those funds were transferred, even though the said provision was later declared to be unconstitutional. The complaint fails to allege facts that would constitute abuse with respect to unprogrammed appropriations, the amounts of the same, the projects and the implementing agencies, and the recipients or the beneficiary of the alleged abuse of discretionary power. There is yet no pronouncement by the Supreme Court that unprogrammed appropriations per se are unconstitutional. Ito naman, mali naman ito kasi nagsalita na si Justice Paul Hernando, na unconstitutional ang unprogrammed appropriations. Number 13, while the statements of Yusek Bernardo might corroborate the statements of former Representative Salvico, there is nothing in the statements of Yusek Bernardo which directly links presidents to any allegation. Number 14, the Cabral files cannot be a basis for impeachment because it has not been authenticated. Number 15, the legal standard of command, responsibility, and personal capability cannot stand because there is no statement that the president knew or should have known about his subordinates or unlawful acts. Ladies and gentlemen, lahat po yan na binabanggit ay kompleto po sa detalye para matanggal si Bongbong Marcos. Pero nangyari, nagbuto-buto sila, binasura nila. Ito, after lengthy discussion on the sufficiency and substance of the complaint, a motion to declare the Masa Ital impeachment complaint sufficient in substance was raised. There being an objection to the motion, the chair divided the panel with 7 votes in favor, 39 votes against, and 0 abstention. The motion was lost. Thus, the Masa Ital impeachment complaint was declared insufficient in substance. So, yan ang ginawa nila. So, findings, conclusions, and recommendations. Wherefore, premises considered, the Committee on Justice finds and concludes that the De Jesus impeachment complaint is sufficient in form but insufficient in substance. The Masa complaint, impeachment complaint is sufficient in form but insufficient in substance. O yan. Klaro na, so binenta talaga nila. Pinirmahan na ni Attorney Jervil Jinky Bitrix Lucaret R. Luistro, chairperson. Okay? So ngayon, ang gagawin natin ay pakinggan natin ang mga opposition na speech nila ni Congressman Reneco. Kasi Congressman sino yun? Si Congressman, dali lang, Antonio Tinio. Ito. Pagpatuloy natin. Ang haba kasi ng speech ni Beatrix yan eh. Ni Lucaret. Ito.
Affirms that impeachment is a powerful process to exact accountability from the government, especially from public officers mentioned in the Constitution. We affirm that accountability, when pursued in accordance with the Constitution, is a core...
Pakinggan natin si Attorney Reneco.
Congress will not be the battles we fought against each other. It will be...
Proceed.
Given 2 minutes.
Thank you, Madam Speaker. Madam Speaker, we just heard the committee report and the sponsorship of our House Committee on Justice Chairperson, Representative Jinky Luistro, on the findings of the committee after it discussed the form and substance of the 2 impeachment complaints lodged against President Bongbong Marcos Jr. But Madam Speaker, I'd like to provide a snapshot of the deliberations and how parts of the discussions were not thoroughly considered and not as reflected in the committee report. Madam Speaker, distinguished sponsor, paragraph 11 of the committee report reads, the Maza et al. Complaint fails to allege facts that would constitute abuse with respect to unprogrammed appropriations, the amounts of the same, the projects and implementing agencies, and recipient of the beneficiary of the alleged abuse of discretionary power. Wala raw pong recital of facts na nagsasabi na meron pong abuso sa paggamit ng unprogrammed appropriations. Pero po, Madam Speaker, nirehistro po ng endorser na to and miyembro ng committee na meron pong clear identification of 3 acts alleged in the facts that constitute abuse with respect to unprogrammed appropriations. Una, ang presidente po ang nag-aproba ng special budget requests na nire-require ng batas that releases approved unprogrammed appropriations items after the budget was passed. Clear din po ang recital na may 213.8 billion pesos na nirelease in unprogrammed appropriations of various fiscal years, of which 111 billion pesos po ang pumunta sa flood control projects that were tagged as anomalous. I can cite din po paragraph 20 to 25 ng Maza et al. Impeachment complaint, ang mga recital of facts na ito. These are alleged to be one of the 3 acts constituting betrayal of public trust. Hindi po accurate ang committee report to say that there's no recital of facts constituting the offense. Gusto ko lang din pong i-correct. Meron din po nakalagay sa report. The doctrine of operative fact recognizes the law is presumed valid and constitutional while in force, assuming that this applies po to the Pimentel Third versus House of Representatives ruling on unprogrammed appropriations. Madam Speaker, I'd like to correct. The doctrine of operative fact, as ruled by the court, does not apply in this case. At pinapabalik ko ang 60 billion na sa PhilHealth. Madam Speaker, the point of all this, marami pong arguments ang dineliver on the floor, na pinaliwanag sa Committee on Justice na sufficient in form and substance yung Maza et al. Impeachment complaint. Repeatedly, ngunit hindi po ito direktang sinasagot. Meron pong ultimate facts na inallege, meron pong verification form, meron din pong...
May we respectfully request the Honorable Renico to please wrap
Yes po, I will wrap up, Madam Speaker. Meron pong recital of facts that makes this sufficient in substance. And the way around it po is nagkaroon po ng botohan that the authenticity of evidence be considered at the level of sufficiency of substance, something that is not practiced or even provided in the rules of impeachment.
Yan na, klaro ha. Yung sufficiency ng authentic na mga evidence, annexes, ay hindi dapat kinukonsidera. Yan, sinistress ni Attorney Renico.
Madam Speaker, my distinguished colleagues, sufficient in form and substance ang impeachment complaint ng Maza et al. At very serious po ang mga allegations na nakalagay ito. Hindi po natin pwedeng itaboy or even hindi tignan. So therefore, I ask this body to be able to vote on the committee report in accordance with principles with conscience nga po, nang may bigat kung ano ang epekto kapag ang panawagan ng mamamayan ng pananagutan sa pinaka-available at constitutional avenue na ito ay hindi po magawa. Thank you,
Thank
Madam
you very
Speaker.
much, Honorable Co-Majority Leader.
Madam Speaker, I move to recognize the Honorable Jose Joboy S. Aquino.
Wala na yan, Joboy. Wala na yan, Joboy yan. Sip-sip yan. Ay, sa Botswana, huwag nyo na iboto tong Joboy Aquino ha, sa agusan. Tangin na to.
Well, the arguments in support of insufficiency
Ilago.
in substance contains a detailed narration supported by 15 paragraphs. Some of the contents in the complaint that were noted as sufficient factual allegations during the committee hearing are as follows. Paragraph 68, page 19, stating that the flood control budget surged by 33% in 2023, the first full budget under the BBM parametric formula, while unprogrammed appropriations exploded by 221%. Paragraph 78, page 20, alleging that the implementation of the managed stage resulted in the concentration of contracts to favored entities, including the President's 2022 campaign donor and firms owned by high-ranking officials. And third, paragraph 84, page 20, as to the fact of the BBM parametric formula's geographic distribution that was determined not by hydrological science, but by the priorities of leaders who needed jurisdiction to host their allocated projects. Also included were the allegations in paragraphs 103, 106 to 108, 111, which supported the second charge of betrayal of public trust in connection to the President's abuse of discretionary power over the release of unprogrammed funds. Again, these allegations were noted as sufficient factual allegations but were not included in the committee report. Third, the finding that the arguments in support of insufficiency in substance of the Masa et al. Complaint, paragraph 15, page 10 of the committee report states that the legal standard of command responsibility and personal culpability cannot stand because there is no statement that the president knew or should have known about his subordinates' unlawful acts. This finding is contrary to what the Masa et al. Complaint narrated in paragraphs 122 to 123. Moreover, it was contrary to what was manifested during the committee hearing that there was bad faith on the part of the president when he personally signed off on a system that bypassed rigorous planning and technical vetting, funneled billions to favored contractors and congressional allies, resulted in 421 confirmed growth projects and thousands of substandard structures, and left Filipino communities more vulnerable to flooding than before. It is therefore clear that the committee report did not faithfully reflect the hearing conducted on the impeachment complaint against President Marcos Jr. Maraming salamat, Madam Speaker.
Majority Leader.
Madam Speaker, I move to recognize the Honorable Wilfrido Mark M. Enverga
Wala yan.
acted squarely within the NTC belief
and to recognize the Honorable Antonio Tino
Natin nyo.
of ACT Teachers Party List for his manifestation.
The Honorable Tino has 2 minutes. Please proceed.
Maraming salamat, Madam Speaker. Nais ko pong i-address ang mga statement o ng mga membro ng mayorya, both sa Justice Committee at sa publiko, sa media, no, na hindi raw napatunayan ng mga endorser ng complaint yung mga aligasyon laban sa Pangulo na betrayal of public trust. Wala daw ebidensyang naipakita. Una, hindi pa po ito ang yugto, yung determination of sufficiency substance. Hindi pa ito ang yugto ng pagpapakita at pagkilatis ng ebidensya. Hindi po yan ang trabaho ng mga miyembro ng komite sa puntong ito. Gayunpaman, nais po nating idiin na sapat-sapat ang allegation of facts sa complaint para sa sufficiency in substance. Meron pong ebidensya sa lahat, lalo na dun sa ikatlong bahagi ng complaint, ang aligasyon na direktang lumahok at nakinabang si Pangulong Marcos sa flood control corruption sa pamamagitan ng pag-utos ng insertion sa BICAM at pagtanggap ng kickback o commitment mula rito. Sa partikular, nasa complaint ng aligasyon na ayon kay Yusek Bernardo, nasa 100 billion na insertion na inutos ng Pangulo, 52 billion ang kanyang direktang hinawakan at mula rito ay nagbigay siya para sa Pangulo ng 8 billion na commitment. Sa complaint po yan. Binanggit sa complaint, ang papel hindi lamang ni Yusek Trajib Olaivar, kundi pati ni Yusek Adrian Bersamin. Sino po ba si Adrian Bersamin? Officially, PLLO, Presidential Legislative Liaison, pero lumalabas unofficially, siya ang runner, bagman at disbursing officer ng Pangulo na tumatanggap at gumagastos ng kickback sa utos ng Pangulo. Merong record ng komunikasyon sa pagitan
Yan,
ni Yusek Adrian.
Yan, record ng komunikasyon. Yan po yung affidavit ni Yusek Bersamin na kung saan nilahad niya na may screenshot ng palitan ng text nila ni BBM.
Adrian Bersamin at ni Pangulong Marcos mula December 2024 hanggang July 2025.
Grabe.
Kabilang dito ang mensahe noong Marso 2024, 2025 ng pagtanggap ng delivery ng 8 billion mula kay Bernardo na pinarating kay Pangulo. Kasama ang acknowledgement o tugon ng Pangulo na okay. Sabi po sa mensahe, complete na po ang 7.122 delivery sa akin. Tapusin ko po ang computation today. Kalakip nito rin ang detalyadong computation ng mga pinaggastusan ng 8 billion na kickback. Kasama po rito, pangunahin ang gastos para sa mga kandidatong sinuportahan ng Pangulo noong nakaraang eleksyon. Kasama rin ang gastos sa mga TV ad para sa eleksyon. Pambayad ng 6 million pesos para sa dayuhang pollster na si Perun na ginagamit
Nagkuha pa sila ng mga survey sa dayuhan na election
consultant ng Malacanang. at 68 million pesos bilang talent fee para sa isang performer na ginamit ng
Si
administrasyon
Andrew 68 million ang bayad. Grabe.
sa kampanya. Nagpatuloy ang komunikasyon na ito hanggang July 2025.
Sapat na sapat ang pagkabanggit. Naku, ba't binasura?
On July 10, pinaabot ni Yusek Bersamin na may delivery siya ng 2 billion pesos para sa Pangulo sa Nara residence sa Forbes Park at sa sagot ng Pangulo. Sasabihan ko si June Baris. This is July 10. The President appears to be receiving kickbacks days before he went to Congress. Humarap siya rito at nagsabing, mahiya naman kayo. Sino po ang dapat na mahiya? Bukod kay Yusek Bersamin, may kopya po ng record ng komunikasyong ito ang isa pang miyembro ng kapulungang ito, si Congressman Leandro Libiste, at pinarating sa amin, sa ilan sa aming mga kasapian dito, kasama si Congressman Erice. Hawak din ito ng isang LGU official na pinagkakatiwalaan ng mga Bersamin. Sa madaling sabi, may malakas na ebidensya sa aligasyon na may alam ng Pangulo ang corruption sa flood control. Direktang lumahok siya at tumanggap siya ng kickback mula rito. At nasa kapulungan ngayon ito kung boboto para patayin ng impeachment at para tuluyan ng maprotektahan ng Pangulo sa investigasyon at paglilitis na tanging magagawa sa pamamagitan ng impeachment. Ngunit nasa kapangyarihan ng plenaryong ito kung boboto ang kahit 1/3 lamang para ituloy ang proseso ng impeachment hanggang sa paglilitis.
Thank you very much.
Meron ba
Honorable Pino?
ritong titindig para malantad ang buong katotohanan ng flood control? Meron ba ritong handang panagutin si Pangulong Ferdinand Bongbong Marcos? Ano man ang mangyari, patayin man ang impeachment ngayong hapon, lalabas at lalabas ang katotohanan. Mananagot ang Pangulo sa taong bayan. Maraming salamat.
Thank you
Madam
very
Speaker.
much. Majority Leader.
Madam Speaker, I move to recognize the Honorable Rolando M. Valeriano of the Second
Brian,
Bansa.
Valeriano. Sip yan.
Violate the rules.
Ito si Reyes,
Under
pakinggan natin.
authentication. The Committee on Justice committed a grave abuse of discretion in dismissing the Lisa Masa et al. Impeachment complaint against President Marcos. It violated Section 5, Rule 3 of our own impeachment rules, which is very clear. Sufficiency in substance requires only a recital of facts and their nexus to an impeachable offense. Nothing more, no proof yet, no authentication yet, no trial yet. But what did the committee do? It conducted a mini trial. It imposed a higher unauthorized standard demanding personal culpability, sworn proof, and even evidentiary authentication at a stage where the rules do not require them. In doing so, the committee cut off the complainant's right to present evidence and testimony in the proper forum, which is the impeachment hearing. Kaya po hindi na-present yung ebidensya. This does not just violate the rules, it undermines the very purpose of impeachment, which is public accountability. When Congress blocks the presentation of evidence, Congress blocks the search of truth. We have seen this pattern before. In the Senate Blue Ribbon Committee, Senator Lacson himself revealed links involving the Bersamins, yet no full investigation followed. The truth was mentioned, then buried. Now we see it again in this House. In the ICI, key commissioners resigned because they knew the truth was being suppressed. When the institutions meant to investigate corruption are prevented from doing their job, resignation becomes a form of protest. And let us be clear, covering up the largest corruption scandal of our time will not protect the economy. It will weaken it. The poorest Filipinos, those already at the margins, will pay the price. At this point, we cannot expect genuine reform from the Marcos administration. They are not addressing the problem. They are only managing the fallout. There is no capacity for self-reflection, no active appetite for real reform. The ICI became a talking point. The Independent Commission law became a talking point. The reform agenda became a talking point. The real goal is survival until the end of the term, not improvement, not reform, not accountability. Dribble here, slow roll there, cover up today, paper over tomorrow. The next 2 years will be directionless, marked by political deal-making to survive at the expense of the people and the economy. As 2028 approaches, the President faces only 3 paths. First, prepare to be prosecuted by his successor. Second, go into exile like his father. Or third, remain in power through chacha or extra constitutional means, a frightening prospect. That is why I vote no on this committee report. The consequences of this mistake are enormous, not just for impeachment, but for democracy, the economy, and the future of the Filipino people. Thank you, Madam
Yan
Speaker.
So, very clear. Very clear na niluloko lamang tayo. Binenta tayo. So, alam niyo na. Alam na this. Oh, hoy, gising. Sabi naman ni Florantigo Tebreyes, 3 years ha? Haha, bakit nyo binibentang sa iba ang ginawa ng mga Duterte? Hindi po issue ang Duterte dito. Walang kinalaman Duterte dito. Bugok ka talaga, Florante. Mas maganda sa iyo ay iban. Ban. So, Boljak, Team Bantag, pansarili lang ni BBM. So, James de la Cruz, nasaan ang sinasabi na ang pag-asa ng bahay ay ang kabataan kung sila ay ayaw natin palitan. Ano ba ibig sabihin? Tapos Linda Maniati, time will come. Luistro, Ridon, Marcos, and all the followers of Satan will pay. Ayan. Enrique Sher. Kalbo. Ay, hindi pwede mang kalbo-kalbo dito. Patayin na natin. Tanggalin ka na natin. Tanggalin na kita dito. So, Linda Banyate, James de la Cruz, hanggang hindi nyo papalitan ang pabalik-balik na Senado, hindi mawala ang sindikato. Renz Dasmastorion, walang patunay at ebidensya kay BP Sara, pero kay BBM ang daming testigo. Kumpara nyo, ang layo ng diferensya. Tapos pagtatakpan lang doon ni Pinky, sabi ni James de la Cruz, Renz Dasmastorion, BP Sara ang susunod ni leader. Si Rogelio Dominguez, damo mo alam, mapakita muna. Kasi ebidensya, kumpleto na nga ebidensya eh. Dami ka na, tanggalin na kita, bubukay. Josephine Rosalihos, nakabalik na naman pala itong ilago na to. Di okay lang, okay naman ang binabanggit, naging fair lamang tayo sa kanya. Perry Pinto, Don Tarangas, hi Dr. to, naghanap tayo ng due process. Ang kay Sara may due process po. Ang walang due process, ang kongreso ngayon, itong kanyo dito na Committee on Justice ito. Hindi nila nirespeto. Due process dapat wala, kulang ang pagkabanggit ng detalye kay Sara, dapat binasura nila. Yun, ang due process dapat, hindi ka mag-double standard. Sini Gonzales, puro kayo impeachment, ang dami ng problema ng mga tao. Victor Salvador, tigilan nyo ng gamit ang taong bayag. Dahil mga nagsampa ng kaso, hindi naman kahit na NPA mga yan, maayos naman pagkasampa, Victor Salvador. At pagkatapos sa impeachment, tapos paupuin si Tamba, wag na. Okay lang, mahal na ang crudo yun. O lithium millennium, no to CPP and PA. At sino pa? Si Madladrad, akyat ka na lang sa bundok. Zini Gonzales, at kayo mga maleta, mga dyan. So si Cruz, ano nangyari? Katuto, wala po. Pinaglalaban ko lang katarungan at saka batas. Kaya walang nangyari na masama. Kayo lang may nangyari masama kasi kinukampihan ninyong magnanakaw na Marcos. Jelo Makalalad, makalakad. Mahilig ka sa peke, wala kang nawa. Ay, ito, tanggalin na ito. Tanggalin na yan. So, malago sa tubig. Good evening, Boss Toto. Mark Joseph, okay. So, sino pa? Gregorio Tagupa. Kaya pala na-disbar. Wala to, tanggalin ito. Tanggal yan. Galing mo ng budol-budol, tanggal din ito. Puro mga bubo eh. Sino pa? Haduken, tapos sa Boljak, sa Marcel Silerio, Double Standard, sa Bergie Piquero, tapos Lina Pinula, binali mga batas dahil sa may kinampihan. Amelia Espiritu, kalbo, magtino ka, tanggalin ito. Yan. Tapos sino pa? Galaxy, ayaw naman niya magpa-hair follicle test. Ano pinakita nila? Bakit nila pinakita? Sino to sa ano ang pinakita nila? Bakit ayaw na ipakita? Hindi ko ito maintindihan po. So, Meme Authority, good evening, Sir Toto. Si Marilyn Bundok, grabe naman ang maleta. Gang. Tapos kay Kumaro, Galaxy. Sandrid Lungasa, sablay ang mga argumento ng Attorney Kausing. Okay, tanggal naman ka. Ayan. Makatang Tambay, good PM, Sir Toto. Yung mga tao na klarong-klaro na, sarado pa rin mata, tatanggalin ko rito. Puro nga pala yung mga naghabla kay BBM hablang kunwari lang. Kaya halatang bayad din ang mga NPA na to. Hindi naman. Danilo Chua, walang hearing ang complaint. Good job, Danilo Chua. Okay? Yan po ang ating presentasyon sa ngayon. Medyo mahaba-haba nga lang ng konti. So, Gibbs de la Cruz, Malo, The Survivor Mixed Vlogs, PM, good evening po, Sir Toto. Salamat po. So, si Eduardo Ligad, tama lang, ikulong ang dapat ikulong. Solid pa rin Duterte from Lady. Tapos si Alexander Cumberter, how come become sufficient when when fishing expectation is on? Ano ba yun? Fishing expedition is on, how they use mini trial. Ay, kay Sara lang sa yung binabanggit. Sa kay BBM po, hindi pang fishing expedition. Wala nang fishing expedition eh. Tumigil ka dyan, Wally. Sino bang Wally? Sino bang Wally? Sinasabi mo. Anyway, hanggang dyan lang. Paki-like na lang po at para pag mag-vlog ko sunod ay notified na po kayo. Paki-join na lang sa channel ko. 75 pesos a month naman po yan. At paki-like na rin ang Facebook page ko na tinanggal kanina. Naibalik ko naman. Nag-apila ako. Ang aking TikTok, aking Instagram, aking Twitter o X. Paki-like na rin po. Maraming